If you had known then what you know now, would you have testified?
Absolutely.
Welcome back. We are watching the final phase of the marathon post-trial hearing for Zachary Adams in Tennessee. Adams is hoping to overturn his conviction in the 2011 death of nursing student Holly Bobo after his co-defendant admitted to lying on the stand during Adams' trial. Now, again, the state rested and there was no rebuttal evidence presented by the defense. Let's go back in now where the state is delivering closing arguments.
I'm going to break my argument down into 4 parts for the court, but before I do, I must say what part of this case is not in dispute. That is that Ms. Holly Bobo and her parents and friends and family are the people who make West Tennessee a special place. The horror of April 13th, 2011 remains an unmitigated tragedy, and nothing I say diminishes that. An outrage that this crime took place is not relevant in these proceedings. The 4 parts to my argument are the story of this case. I'm going to address constitutional violations. I'm going to address the proceedings themselves, these post-conviction proceedings themselves, and end discussing the obligation that the court has. Before I get too technical in the legal arguments, I'd like to just summarize this case. April 13th, 2011, a beautiful young nursing student was taken from her home, traveled in a clockwise manner until her cell phone stopped traveling for 30 minutes. This is where U.S. Marshal tracking expert suggests she was killed. No evidence before that was found along a route. A bullet consistent with a defect in her skull was found next to her remains. Evidence was thrown out for personal belongings from that location along the route that ended at Gooch Road. Most of her personal belongings were found next to her remains. I will not belabor the evidence that made law enforcement and General McAdams submit there was probable cause that Terry Britt committed this crime. Britt had a search warrant served on him and installed, while he was briefly incarcerated, various wiretapping and bugging devices. Soon after he returned, he was told, "They probably are bugging you." Nothing happened. 2011 turned into 2012, turned into 2013. This case was becoming a cold case. Terry Britt told Marshal Walker to get an agreement giving him certain prison time. He just wanted his wife Janet kept out of it. He was not Mirandized. He took 15 years on old charges that Janet Britt was let out. By the way, if he had been serving for that crime that happened in Madison County, he would have been incarcerated on April 13th, 2011. In the words of Brent Booth, this case is haunting. As time developed, TBI blamed the Bobo family. The Bobo family blamed TBI. Nobody could blame them. What follows that began in late 2013 can only be explained by understanding the juxtaposition of impenetrable truth that scientific data provides and the manipulative propensity of what people say. And these people who are either scared, want reward money, or have their memory replaced with inferences and impressions to regurgitate or, quote, nail down. Enter Dennis Benjamin.
All right, let's bring in our guest this hour, criminal defense attorney Frank Lanham. Frank, great to see you, my friend. I hope you had a wonderful holiday. Frank, I want to start here. You know, courts in this country, they place a high value on the idea of finality, right? Once a jury verdict is reached and upheld, our justice system pretty much assumes that that case is correctly decided. But Frank, that being said, how high is the legal bar here for the state to overturn a conviction like this one? Because I'm sure the judge doesn't want to set some precedent for endless relitigation of old verdicts.
The bar is impossibly high, almost to a degree. But it's this, I was just sickened to hear the prosecutor's argument, and I'm going to look and read what she said. Our job is to protect the conviction. That is the exact same argument prosecutors made in 1940 when black men were convicted of raping white women and there was no evidence except what someone said, and they still saw their job as not doing what was just or right, but to protect the conviction. The same argument is being made today. Maybe we're not targeting black men, but it's poor men with coerced, threatened evidence. You're going to prison forever, or you say this. And then I hear that when the person says it didn't happen, no one seems to care. The judge excludes that. Could you imagine sitting in prison when the only evidence is one person says you did it? Everything says you didn't. And the judge says, we're not going to consider that. The prosecutor fights considering that. Their job is to do justice. I'm sick of hearing this preserve the conviction. Their duty is to do justice. And I didn't hear a word of justice come out about their position when you played the links of the prosecutor.
Frank, that is quite the comparison. You know, going decades back to today, I see the point you're making there. You're standing by with us this entire hour, Frank. But coming up, closing arguments continue in the final phase of the evidentiary hearing in Zach Adams' bid for a new trial. And also, we are looking ahead to trials kicking off in the new year. In Georgia, 17-year-old Sarah Grace Patrick is set to go to trial January 5th. Now, she's accused of killing her mother and stepfather, Kristen and James Brock, in February. The two can be seen in this image posted to Daniel Patrick's Facebook page back in February. Now, Court TV will bring you the latest in the deadly teen daughter murder trial in the new year. We'll be right back.
Did you kidnap Holly Bobo?
No, ma'am.
Did you rape Holly Bobo?
No, ma'am.
Did you murder Holly Bobo?
No, ma'am.
Did you have anything to do with the disposal of Holly Bobo's remains?
No, ma'am.
Welcome back to Court TV Live. Of course, I'm Cody Thomas. Now back to Tennessee, where convicted killer Zachary Adams is back in court for the end of a days-long hearing as his defense team fights for a new trial. Now, nearly a decade ago, Adams was found guilty for kidnapping, raping, and killing 20-year-old Holly Bobo, who had disappeared from her home 6 years earlier. Now, during the trial, Jason Autry, Adams' co-defendant, testified he witnessed Adams kill Bobo. But now, years later, he's saying he made it all up. Now, Adams' defense is now appealing his conviction based in part on this new information. Let's go back into the courtroom now and listen to more closing arguments from the defense.
Enter Dennis Benjamin. He begins working with TBI head agent Jack Van Hoosier, retired cop, becomes the go-between between the Bobo family and TBI. His job was to get some arrest. Enter Sheila Kilser. Her son was arrested with Jason Kilser. Put aside that both Sheila and Jason had already denied knowledge or involvement. Sheila and Jason get law enforcement to believe Dylan knows more. TBI pounces. Even though what Sheila heard was false, TBI begins the belief that continues throughout that they have the omnipotent superpower to know what the truth is. And thus anything that points to arrest is true enough to further their aim. This is a central theme of everything you've heard. Dylan is pressured from jail. He gets a sweetheart deal, the contents of which are under seal. I will not discuss that. I would just ask the court to read it. word about Dennis Benjamin. He had been told in February of 2014 by Victor Densmore that Dylan was the weak link. In March of 2014, Benjamin is back in Indiana telling Densmore that he's going to get the death penalty if he doesn't tell him where the body is. In dismissing Benjamin, Densmore says, "I'm not even interested in the reward money." We are to believe that a drug addict's statement to his girlfriends, his drug buddies, and other jail inmates are gospel. All are statements that were provided or not provided or misconstrued to the most vulnerable of our citizens. They were worried about arrest, losing custody, reward money, and thus everything the state has mustered in an ambush of these people, or to put it into their words, run to the ground. Persist until they say enough to implicate these four, even if it's inconsistent, even if it's demonstrably false. It doesn't matter. I could not summarize this part of the case better than Agent Joe Walker did on page 483. There were a lot of statements that ended up not being true. Now it's time to find the credible points of data that corroborate this scientific data that cannot be manipulated. None exist. Every single part of their life was searched for DNA evidence. None. Fingerprints. None. A gun that could have been used in the crime. None. Nothing. Not the palm print at the Bobo house. Not the crop print. Not a single thing. They have that a meth addict scratched his arm. Dylan's statement is thoroughly rebutted by the cell phone records. It's no wonder why within weeks of Jason Autry's story being released, his attorney wanted the cell records just one more time. Instead of saying Dylan's story was not true, the state has tried more creative avenues by saying it was too self-serving. After he made the statement, he was politely escorted to jail where he has been ever since. Fugitive tracking experts placed the location of death where the remains were found. He was needed to be an expert when the state was trying to solve this crime. You heard from Agent Frizzell today. When his opinion did not fit within the strictures of the manipulated testimony, he was discredited. Could not show it any better today. Agent Frizzell and I recreated Marshall Walker's map. The foundation of my entire trial has been trying to explain April 13th, 2011, and when I finally had Agent Frizzell under cross-examination, he showed the same thing. Bank records were pulled of Shane Austin to call his bluff to see where he was. They confirmed where he was. He said he had a satellite guy coming. That too was corroborated. Cell records put these four throughout Decatur County and Benton County, and it never put them in Swan Johnson Road's location. Zach Adams' phone, that apparently was with him all the time. At 8:19, he's receiving incoming text. 8:17 and 8:26, Miss Holly Bobo's cell phone is on a completely different tower. Facebook showed Zach online that morning. Nothing made sense, and yet these men were on trial for their life. Zach Adams' defense attorneys were told, get the ATM video by Dr. Norton. The bank said no such software existed, and TBI agents said the ATM transaction was not covered by their videos. Someone had mislabeled them to be a BP video. Thompson couldn't even open whatever it was labeled BP.
All right, coming up next, more closing arguments in Zach Adams' fight to overturn his conviction in the murder of Holly Bobo. Keep it right here on your front row seat to justice.
The world's attention is focused on what we are doing here.
He claimed dying was not a crime, but prosecutors thought it was.
This is a murder trial. Jack Kevorkian killed by injecting him with drugs.
Dr. Kevorkian has never in life intended anybody to commit suicide.
He was the only person that could help.
Michigan versus Dr. Jack Kevorkian. The trials of Dr. Death, weekdays at 2 Eastern on Court TV, Legendary Trials.
Back to Tennessee, where Zach Adams is seeking to overturn his murder conviction. Now, he's back in court for a long-running evidentiary hearing. Now, this days-long post-conviction relief hearing got underway last month and took a break before resuming this week. Let's go back inside the courtroom now for the defense's closing arguments.
Watch the tape. You have a transcript. I can't request enough. Absorb it. Dylan says whatever they wanted him to say. And so initially, during these proceedings, I was asking, they started off with Mark Lewis. And we get into this, what I'll refer my words as hedging. Again, to the jury in 2017 is totality. Autry's plea, Autry tells the world. Judge McGinley, most persuasive, credible testimony I've ever seen. Watch what happens in 7 months. General Wyrick is asking the first TBI agent to testify, Mark Lewis. Question, this is page 238. Is it fair to say that Jason Autry's statement that he's given to law enforcement over the years, as well as Dylan Adams' statement that he's given to law enforcement over the years, are not mirror images of one another? They're not mirror images. How many homicide statements have you participated in your career as a TBI agent? I don't know what the number is, but it would be a lot. Okay. How many of those have involved a co-defendant? A fair amount. Is it typical with co-defendants pointing the finger at one another? That's not uncommon. It's typical. Sometimes they do, sometimes they don't. Sometimes they give you a little bit, try to mitigate their own involvement. That has happened, yes. Give you just enough to let you do your work without completely, and I object. I said, Your Honor, is the state acknowledging Jason Autry's statement and testimony was false? Because that will save us a tremendous amount of effort with this line of questioning if the state is acknowledging that Jason Autry's statement was false. General Wyrick, I'm nowhere close to that, Your Honor. No, sir. Now, fast forward to Kathy Ferguson. May, August. General Wyrick asked Kathy Ferguson, of the 4, who do you think raped Holly Bobo? She said Zach Adams, Shane Austin, Dylan Adams, and Jason Autry. Oh, so you think Jason Autry raped him? Yes. All because you just listened to Dylan Adams' statement. And you realize it's a lie. Now, General Nichols says 2 things on her testimony. She said, initially, I knew it was false when I watched it. She and I agree on that totally. It's interesting, though, he got incarcerated immediately after making it. I know of no other crime where you say a lie about your involvement in a crime and you're not arrested. The problem is when Jackson and Booth are good cop, bad copping him and saying all this, nobody had the cell phone data To say that this is not a mirror image of Jason Autry is an offense to the mirror. Dylan has this concoction coming up over the entire night and has Autry the ringleader, has Autry throughout the day raping her, has Dylan raping her, has Zach raping her. Then, when you watch it in full, you'll get to the point when they say, and they were hiding her in a basement. It's like, oh, whoops, they're talking about a trailer. So it starts all over. And you go back to the sealed transcript of the plea deal. And you think about Dennis Benjamin and what we heard from him. February, meeting Dinsmore's a God thing. He's got a friend in Indiana. March, he's lying to him, saying you're going to get the death penalty. And that's who the vulnerable one lived with. I want to say this about Autry's lie. Credibility matters. I got the pattern instructions. Pattern instruction 42.04. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. By the way, the dedication to this year's pattern instruction was to Judge German. Judge Riley wrote, Dickey abhorred anything he considered to be an injustice. But the state says, okay, in 2017 we said Jason Autry, total mourning, total testimony, total truth.
All right, let's bring back in our guest this hour, criminal defense attorney Frank Lanham. Frank, we just heard the defense attorney there say these words, credibility matters, right? And he's talking about Jason Autry. We know, obviously, that's the big, kit and caboodle of this case right now is that Jason Autry recanted those statements about seeing, the murder happen, right? So when it comes to Jason Autry's recantation, how credible can it be when it comes from this witness who previously cooperated with prosecutors for a deal to keep him out of prison, when we're talking about credibility here?
Well, it's kind of simple. This is legal bribery. Now, I'm not saying the prosecutors were illegal, even unethical. I'm saying they committed legal bribery. If I offer $10 to a witness to say a word, I'm a felon. They can give you your whole life, 15, 20, 25 years. And by the way, that deal apparently is under seal. So the jurors don't always know what they get. I had a judge recently tell me I couldn't tell the jury in a very similar situation that the person saved 30 years of his life. You are seeing legal bribery in action. Not only that, you're not hearing from the man who recounted his evidence, because only the state can grant immunity. If you get immunity, your Fifth Amendment right to not testify goes out the window. Can the defense do that? Nope. It's not a fair playing field. Jurors sometimes buy things. If I'll reference my earlier analogy of black men in the 40s, the jurors didn't flinch then either. But somewhere when there's a lack of evidence and just emotions of a horrible crime, we have juries and then we have legal standards. And sometimes it takes both of them to make sure there's not an injustice. This sounds terrible.
And Frank, just real quickly here, we only have a few seconds left here, Frank. Even if Autry's recantation does cast some doubt, right, does it automatically undermine the jury's verdict from years ago? Not that in itself. If there were 10 other things, it wouldn't. But when you've got nothing else that's guilty, it's got to matter. Somebody has to care if this is right or wrong, and that's where the judge should come in. Right or wrong matters. Absolutely. I couldn't have said it better myself there, Frank. Right and wrong does matter. Now, Goodbye to Frank Lanham. Always a pleasure to have your insight during the show. Great to see you, my friend. I love that Harley Davidson leather jacket you had going there. I'd love to see what kind of bike you ride one day. Coming up next hour, more closings in the post-trial hearing for Zach Adams, and also, oh, that's it. Welcome back to Court TV Live. I'm Cody Thomas. Now our focus this hour is on Tennessee, where Zachary Adams is back in court this week in his bid for a new trial. Now Adams was convicted in 2017 of kidnapping, raping, and murdering 20-year-old nursing student Holly Bobo and is serving life without parole. Now Bobo disappeared from her family's rural home 6 years prior to that conviction. Now investigators found no DNA linking Adams to Bobo or the site where her remains were found. Prosecutors instead relied on testimony from Adams' co-defendant, Jason Autry, who said he witnessed Adams kill Bobo. Now, years later, Autry is saying he made it all up, recanting the testimony that ultimately got Adams convicted. Now, his defense team is now seeking to overturn that murder conviction based in part on that new information. Now, last month, Adams took the stand during this months-long post-conviction hearing, denying under oath he had anything to do with Holly Bobo's death. Now let's get you back in the court now, where the defense is wrapping up its closing arguments.
Could not say it better than Forrest Richardson. He analyzed quantity, not quality. Jennifer Thompson's problem is not that she didn't know the case. She couldn't tell the jury about it because by September 2017, she'd been ridiculed. Her own co-counsel filed a motion to withdraw, saying her problem was she believed him too much. I'm curious what the state's position is. Is it that she was competent, or in the words of Jennifer Nichols, dishonest and unethical? For recording her work. Can you imagine if we didn't have the recording of Dinsmore and I was trying to tell you, Judge, I think there was perjury suborned during that day. I think Dinsmore said he didn't remember. If I didn't have a recording, they'd be like, whatever, trust us. Which brings me to the third large point. When you reflect on this case, whose presentation provided you the most credible proof? Whose statements to you were true? I told you from the beginning in May, Your Honor, Katie Spirko won't be a witness. You look in the record right now to see if there was ever a subpoena issued for her today, served on her today. I said it's for a nefarious purpose. Opening statement. The state said, if there's anything new that comes to this court, it's not going to be credible. I submit I have presented to the court objective scientific data that cannot be manipulated, like testimony of a fisherman 14 years earlier. The state has provided testimony from witnesses who lied about everything until their lies were nailed down to the lies of others. It was, at one point I asked a question and General Hagerman volunteered, this isn't gamesmanship. What else is it? If you don't think Jason Autry did it, then why continue to try to put him to death in pleadings? And his answer was, well, we didn't know who was going to be tried first. This is not a game. I've told you about the .32 revolver that we've never found from Dick, the second one apparently. Spin in a pond. Think about this. The state has asked you to consider the prior evidence, which is part of the record, that Zach made all these statements to drug addicts, to friends, to girlfriends he was fighting with, as somehow confessions. They have incarcerated him since March of 2014, had the ability to wiretap every single thing he's ever said, listen to every phone conversation he's ever made. They don't have the first sentence uttering a single statement that he had any knowledge of what happened to Holly Bobo or any involvement. They say that he threatened his brother. If that's the new element for first-degree murder, every parent who has children better watch out. And look at the people who supported the scientific evidence. Look what happened to them. Terry Dykes taken off the job. John Walker reported. Jennifer Thompson, antidepressant medicine. And Your Honor, I submit I have shown this to you, and in this case, I have taken their witnesses and their evidence, with the exception of Paul Dillon, Alberto Davis, and Bradley Strong. No, sorry, that's their witness. And the lawyers involved. I've taken their IRs, their agents, and shown you the truth. Your Honor, we're now time for me to tell you the fourth part of this argument and the last part of this case, which is your signature to the order. This procedure, this post-conviction procedure, Rule 28, and it's codified, reflects our country's dedication to the importance of our Constitution. Just as Marbury versus Madison said, some laws, however popularly passed, will not stand if they're unconstitutional. Neither will a jury verdict stand if it's the product of a constitutional violation. These provisions are not trivial. Due process, effective assistance of counsel. I will not lecture the court on the Constitution. I will just say this. It's what our men and women in uniform defend with their lives. Every judicial oath states you solemnly promise to support the United States and Tennessee Constitution. Each generation of Americans inherit the obligation to honor it, and if they don't, it will not stand. At times, it requires good and honorable men and women to speak up and stand up for it against powerful and popular forces. Is your signature going to be easy? Your Honor, it's not. The Constitution doesn't care if it's not easy. To put it in more practical sense, can TBI officers go around telling other witnesses to change their testimony to nail down with other testimony, and can prosecutors say, that's fine, let's use it? We'll find out with your signature. Can a prosecutor lie to the jury about a bullet size? We'll find out with your signature. Can a citizen honestly be said to have had effective assistance of counsel if the attorney was ridiculed, her first chair abandoned her, she had mental health problems, she never presented alibi evidence, she did not understand what evidence is important and how to get it admitted? We will find out with your ruling. Can a state mislabel, then lie about its existence? Evidence that either exonerates or tends to exonerate the witness, and then when they find a more clear version of this evidence exists, can they surreptitiously obtain it and tell the custodian, don't say a word about it? We'll find out with your ruling. Here's the irony, Your Honor. This ruling's not going to affect me. I'm going to go back to Hickman County and divorce people. I can tell you who is waiting on your ruling. Every dishonest member of law enforcement and prosecutor that is faced with a weak case. Your green light, if you condone this, will be the best they could have ever hoped for. And to be clear, I am not saying every law enforcement or prosecutor in this case or throughout the state is either dishonest or corrupt. We live in a state that prides itself in law enforcement, and we should. Those who do their job honorably have the utmost regard for everyone in this courtroom. It is to them this court owes the duty to not reward the bad conduct that besmirches their life's work. I would read to you from page 504, retired Agent Joe Walker, to be your guiding light. If there's evidence that cannot manipulate that Zach Adams was not part of this crime, you want him out of jail, don't you? If Zach Adams was in jail unnecessarily, sir, I couldn't sleep at night. I can promise you that. Is today the first time you learned that you did not look at the right video? Yes, sir. Do you feel terrible? Again, sir, I don't know. I don't feel terrible until I know for sure. You're worried, aren't you? I would hate to think that it would be, but I'm not certain at this point. No, sir. Chaucer wrote in Canterbury Tales, if the gold rust, what chance does the iron have? If Chaucer were here, he would say it this way. If this conduct in this case is not corrected in such a high visibility case, what's going to happen to the low visibility ones? Your Honor, subject to any post-trial filings as the court requires, this largely concludes my appointment to the court under Rule 28, Section 610C2, whereby I have reviewed the pro se petition, filed the amended petition asserting other claims which the petitioner was arguably entitled to, interviewed relevant witnesses, diligently investigated and presented all reasonable claims. To say that this has been disappointing and at times disgusting and even intimidated to present to the court would be an understatement. I read no such exceptions to Rule 28 that could have made this easier for me. I would be lying if I did not say I wish such exceptions existed at times. I found myself this summer working late at night often on this case and moving offices across the square in Centerville. One artifact I came across was an article in the Hickman County Times from 1981 where the then assistant prosecutor resigned because he was so upset at the corrupt, dishonest judge who presided over the court. The prosecutor not only wrote the resignation to the judge and the DA, he allowed it to be run in the Hickman County Times. The letter reviewed in detail the horrible acts from the bench this prosecutor had witnessed. And he ended it by acknowledging that this resignation made public will cause a financial cost to his future that he regrets. But he would rather his children grow up poor than to witness him stand silent in the face of such corruption and dishonor from the very institutions we cherish most in our country. The author had a daughter who has since taught history and government and a son who followed in his footsteps. For the reasons I have cited to you, Your Honor, I'm asking you to not stand silent either. Thank you.
All right, we do need to take a break now, but coming up, we'll get you back into that Tennessee courtroom for more of the post-conviction hearing and Zach Adams' bid for a new trial. And we want to let you know about a trial we will be bringing to you here live on Court TV in the new year, the Killing the Messenger murder trial. Now, 81-year-old William Brock faces murder charges for the fatal shooting of an Uber driver who investigators say was sent to his home by scammers demanding money from him. Now, the horrifying encounter was caught on the driver's dash cam, and that trial is scheduled to begin on January 12th, and you don't want to miss it. Keep it right here on Court TV.
I'm going to ask you a lot of intensely personal questions.
From the crime scene to the courtroom, this is Victim to Verdict.
Everyone has this heightened sense of anticipation.
What a day here at Court TV.
Fireworks both inside and outside the courthouse.
Let the cameras roll.
I don't care if death penalty's on the table or not. Absolutely, I'll to my dying breath, I'll be innocent, and that's the truth.
Back now to Tennessee, where we've been following today's post-trial hearing for Zachary Adams. Now, Adams has filed a request to overturn his conviction in the kidnapping and murder of Holly Bobo with the hopes of being granted a new trial. Now, this comes after his co-defendant, Jason Autry, recanted a testimony that solely got Adams convicted to life without parole. Let's head back into the courtroom now and listen to the state's closing arguments.
We do not care where Zach Adams was at 11:12 in the morning on April 13th, 2011. The state of Tennessee could not care less where he was at that time on that day. Out of their own witnesses' mouths, Agent Terry Dicus, the operative, the key, the essential time period in this case, in this investigation, 9:39 in the morning. He elaborated a little more and said from 8 to 10:30 in the morning. That was the key time. Their own witness. This court has heard proof since May. The jury heard proof for a week. Thousands of pieces of evidence have been admitted before Your Honor, before Judge McGinley. Often when we wrap up jury cases, we say to the jury as prosecutors, particularly cases like this, it's hard to give it to you. It's hard to turn this case over to you, ladies and gentlemen of the jury. We know you've been listening. We know you've been paying attention. We chose you. We know you're going to follow the law, but it's still hard to hand that case over. Your Honor is the jury here. And the state of Tennessee has the utmost confidence that Your Honor is going to do the right thing, that Your Honor is going to follow the law that says that they have to prove beyond clear and convincing evidence, or with clear and convincing evidence, that Jennifer Thompson and Jim Simmons and Jerry Gonzalez performed below reasonable standards, not magician standards, not wizard standards, not Could you maybe bribe a juror and get them to hang this thing up? But did they perform at reasonable, objective standards in the moment? Not looking back. All these years later, with hindsight, and I'd have done it differently. I'd have done this instead. Did they meet that standard? If they did, we're done. And Your Honor can proudly put your signature on that order. If they didn't, they still have to prove that it would have made a difference. That when that jury came back into this courtroom, if they'd heard everything that Your Honor has heard today, plus everything that they heard during the course of the week of that trial, that they would have come in here and said, you know what? I don't know. Or just one of them. All it takes is one to say, state didn't meet their bargain. I can't sign my name on that. Would any of this have made a difference? State submits that the only difference what has transpired in this courtroom since May and outside of this courtroom in an attempt to manipulate these findings, in an attempt to manipulate and threaten witnesses, that the only thing that has changed standing here today, December 29th, 2025, is we know even more certainly how guilty he is. When we started these proceedings in May, the state pointed out that he, the defendant, sits before you, a convicted murderer in the state of Tennessee. And it's louder today than it was when we started in May. Because what the petitioner is asking the court to do is to look at the proof through a straw. Please don't read all of Mike Frizzell's report. Let me just scream and carry on about how the state hid evidence. If it wasn't so tragic to sit here with the Bobos in 2025 and watch them go through this. It's comical to carry to its ultimate conclusion what the petitioner is asking the court to believe. Please don't look at all of Mr. Frizzell's report. Just focus on the fact that he put that fourth ping on a later page. At no time did Mike Frizzell today or ever in front of that jury say, just look at this little piece of what I found. Look at all of it. Everyone who testified in this courtroom before Your Honor and who testified before that jury, with the exception of a few that I will talk about, everybody, from law enforcement, look at all of it. Got it all. Here it is. I would hazard to guess that never in the state of Tennessee, perhaps in any state, I don't know, but in the state of Tennessee, never has a trial been conducted where the defense team had everything the state had. Everything. So this same petitioner who wants the court to believe that we're over here manipulating witnesses and telling people what to say and hiding stuff in our bags, I don't know, they had it all. They had it all. And we were at their mercy to receive the information. We were at their mercy to receive the information.
All right, let's bring in our guest this hour. Joining us to discuss is the Chief of Police of Talladega College and retired homicide detective Chris Anderson and Los Angeles-based criminal defense attorney Silva Megardician. Great to see you both. I hope both of you had wonderful holidays this past week. Now, Chris, I want to begin with you. We heard the state here just say, we know now even more, certainly, how guilty Zach Adams is. Now, you being the retired homicide detective, if you recall, there was no DNA or physical evidence definitively linking Adams to Holly Bobo or the crime scene, meaning the prosecution obviously relied heavily on witness testimony, witness narratives, and circumstantial evidence. You know, the defense even going as far to say the state was more in pursuit of closure than they were of the truth. Now, with this lack of physical evidence, my question is, how much weight should a jury give to testimony when there's no forensic proof to really back it up?
So thank you for asking the question, because I think that's a very important question. But before I get started, I got to say I offer my deepest condolences to the Bobo family. They are the ultimate losers in this whole case, because first off, you've asked this family to sit through not only going through the grief of losing a child, but they've also had to go through not one but two trials, or multiple trials, as a matter of fact. So, and this whole case, this whole trial that they're going through now is only bringing up the hard feelings of knowing that they've lost their child. So I offer my prayers to them. Now, to address your question about whether or not the jury should or they should, how much weight should be levied against the not having DNA cases. I've worked over 300 homicide cases in my career. I would have loved to have DNA evidence in every one of those cases that pointed directly to the defendant and to priest and a judge that were witnesses, but you just don't. It just doesn't happen like that at all in all cases. In most cases, you don't have DNA evidence that points directly to them, and then even in some that you do have DNA evidence, you have to really weigh that in how it was found, how it was collected. So, you know, do I think that it should it be thought about? Absolutely, but should it completely throw the weight of the case against saying that this man is innocent? No, I don't think so.
Right, because people have to remember there was a time when we didn't have all this fancy technology and convictions were still brought upon defendants in cases nationwide. Silva, my question to you. Now, obviously, Jason Autry's recantation, this is probably the biggest grounds for the defense seeking this new trial here. Now, does this recantation alone create enough doubt to justify starting over, or is this more so just the kind of post-trial noise that we usually see out of these high-profile convictions?
Well, hi, Cody, and thank you so much for having me on. And, you know, just also, Mr. Anderson is so right. You know, heart goes out to the Bobo family because, again, going through this emotionally for victims' families is so difficult. But I will tell you, Cody, to answer your question, the recanting witness is not enough by itself, right? Even though that was the main line of evidence is that he was convicted in the first place, but it's a cumulative standard and it's an extremely high standard. That alone is not going to lead to the judge to overturn this. But cumulatively, if the judge believes that a jury's verdict would have been different had they had this before, had the attorney been, let's say, more prepared, which I do think is the weakest argument that the defense has in this case. The fact of the matter is, defense counsel from that first trial looked, no matter what, even though she had gone through depression, mental illness, and the other attorney had left, it looked like he had proper representation. So the judge has to think of this cumulatively when making his decision.
Chris and Silva, you know we appreciate you both, your insight on such complex cases. We love having you on. You guys are sticking around for the rest of this hour. But we do need to step aside. On the other side of the break, we'll get you back to more closings in the post-conviction hearing for convicted killer Zach Adams. Welcome back to Court TV Live. I'm Cody Thomas. Now back to the post-trial hearing for convicted killer Zachary Adams. Adams and two other men were charged in Holly Bobo's death, with Adams being the only defendant choosing to go to trial. Now at that trial, key witness Jason Autry testified in graphic detail about how Bobo was kidnapped and raped before being wrapped in a blanket, thrown in the back of a pickup truck, and killed under a bridge near a local river. But now Autry is recanting that testimony as Adams claims that he made it all up in an effort to keep himself out of prison. Let's head back into that courtroom now and listen to more of the state's closing arguments.
But even for the sake of your honors responsibility, and the incredible job in front of this court. Let's just say, for the sake of this argument, that it is clear as day that you can see the A-team in the front of that truck pulled in backward at the bank at 11:12 in the morning. Who cares? Holly's already dead. If that video had been taken between, let me make sure I get the times right from Agent Dykas, between 8 and 10:30, and you could see anything, yeah, that's a pretty good alibi. But the time is irrelevant. The state couldn't care less, nor does the law care where this convicted murderer was after he'd already killed Holly Bobo. And all that the court heard in terms of alibi from Dylan Adams and this defendant was where they were after they killed her. Don't look too closely at what the proof shows as to where we were while she was being kidnapped, raped, and shot in the back of the head at the Tennessee River. Don't look too closely. Jennifer Thompson whether she looked at the video or not, she did spend time before going to law school as a computer programmer. And I think the court can see from the evidence that was admitted, the tech-savvy ability that she had. She knew what she was doing. She was an experienced attorney at the time the family hired her. She served then, she serves today on the CJA panel. Every accolade that you can have thrown at you as an attorney has been thrown at her. This one just didn't turn out the way she wanted. Whether she saw it or not, it doesn't matter. Because she had a strategy. And she had the best defense that has ever been handed to a defendant in the history of the state. And his name was Terry Britt. He looks and walks and talks like and is a registered sex offender. And it only takes one to not listen to all of the evidence and all of the facts and all of the law. That was her strategy. Imagine if this were all reversed and she had put the defendant on the stand and he had done a bang-up job at trial just like he did before the court with his selective amnesia. Oh, I don't remember where I was. Oh, I don't know where I was. No, I didn't say that. That was just a joke. Imagine if she put him on the stand and he had testified and that jury went back and convicted him. Then the accusations from this side would be, you should have blamed Terry Britt. You've got this walking poster child. Every defendant accused going forward is going to point at him. Why didn't you put on Terry Britt? Why would you ever put on proof putting these guys together? That's why the video is useless. Even if it showed anything, even if the time helped, why would she want to put them together? Her defense was to distance him from the others, the A-team, and to pin this on Terry Britt. But in addition, she didn't just sit back on her laurels with that as her sole objective. She cross-examined the fire out of just about everybody that took the stand. Can we sit here in 2025 with hindsight and say, oh, but you should have asked it this way? Sure, we can do that all day long. Thankfully, that's not what the law requires. The mandates of the law are for the court to look at the totality of the case at the time. And at the time and in the moment, and given what Jennifer Thompson and her team of 24 people that were working day in and day out around the clock while this case was in trial Their strategy was golden, easy, succinct, easy to understand. Very rarely does a defense attorney have a name to put on the some other dude did it defense. This jury got to meet him and size him up and listen to her cross-examination and take it all into account and weigh it all.
Coming up, we will continue our coverage of the post-conviction hearing for Zachary Adams, and we want to look ahead to another big trial we will be covering in the new year, the au pair affair murder trial of Brendan Banfield. Banfield is charged with murdering his wife and a man who answered what prosecutors say was a fake post on a fetish website. Prosecutors say Banfield and the family's 23-year-old au pair plotted the murders as part of their romantic affair. That trial is scheduled to begin January 12th. Catch every moment right here on Court TV.
The world's attention is focused on what we are doing here.
He claimed dying was not a crime, but prosecutors thought it was.
This is a murder trial. Jack Kevorkian killed by injecting him with drugs.
Dr. Kevorkian has never in life intended anybody to commit suicide.
He was the only person that could help.
Michigan versus Dr. Jack Kevorkian. The trials of Dr. Death, weekdays at 2 Eastern on Court TV, Legendary Trials.
Back to Tennessee for the post-conviction hearing for Zachary Adams. Now, nearly a decade ago, Adams was found guilty for kidnapping, raping, and killing 20-year-old Holly Bobo, who had disappeared from her home 6 years earlier. Now, Adams' defense is now appealing his conviction based in part on the fact that his co-defendant, Jason Autry, says he made up his entire testimony where he claimed he witnessed Adams killing Bobo. Now, let's go back into the courtroom now and listen to the rest of the state's closing arguments.
Has great confidence and faith in this court. And just as much confidence and faith in our system. A system that provided this convicted murderer with every piece of evidence that the state gathered to prove his guilt. A system that allowed his team of lawyers and experts and jury consultants and forensic experts, and I mean the list is as long as this aisle. A system that never said no, that's too much money. We're not going to pay for it. Everything that Jennifer Thompson requested was granted. A system that selects from the community men and women, not lawyers to second judge and second guess. Men and women of a community to listen to the law, to listen to the facts, and to never, ever, ever leave their common sense behind. A system that instructs that jury of their incredible responsibility that you must, every one of you, all 12 of you, find beyond a reasonable doubt that Zach Adams raped, kidnapped, and murdered Holly Bobo. A system that made everything available to him. Ms. Thompson was hired by his family and then convinced the court to appoint her. She kept him off death row. And a system that allows Your Honor to look at everything, what the jury heard, with the added benefit of what the court has heard now. And the absolute unbelievable testimony that she just doesn't recall what he said, or that all of those communications with her client, every note she took, is missing. It's not plausible. The focus group that we asked her about, for a minute there I thought, well, geez, did we read something wrong? And she had zero memory of that. And the court saw from the bar graph this morning from Forrest Richardson, 40 hours spent on a focus group. Dogged, relentless, obsessed. Zach Adams was afforded one of the greatest defenses and defense presentations and defense teamwork of any accused criminal in this state, to the tune of $275,000 for Ms. Thompson alone, just during the time that she was appointed. The standard that the law requires is light years beneath what she gave him. And even her dogged, relentless, obsessed attention to detail, quest to win, desire to beat Jennifer Nichols, none of it mattered. Because in the great state of Tennessee, in these courtrooms, the law is the boss. The law that jury followed and proudly walked back in here and returned their verdict to Judge McGinley, and the same law that Your Honor will follow. The same law regarding credibility of witnesses, reasonableness, prejudice. Would any of it have made a difference? The state submits the only difference is that verdict would have been a lot faster.
All right, that is wrapped up for the day. Both sides have settled. Now the judge will issue his ruling within 60 days.